Welcome to Module 8, Faculty Academic Freedom and Property of Work. This week we will be discussing the concept of academic freedom from a faculty member's perspective, including the educational and legal definitions of academic freedom, as well as an exploration into academic freedom case law, including First Amendment rights of faculty. Additionally, the concepts of intellectual property, copyright law, and fair use will be explored through our lecture and readings. Academic freedom for faculty is considered to be a critical legal issue in protecting faculty rights and ensuring the ability to exchange ideas within the educational setting. The interpretation of academic freedom does slightly differ between institutions and the legal definition. According to the American Association of University Professors' 1940 Statement of Principles on Academic Freedom and Tenure, institutions of higher education are conducted for the common good and not to further the interest of either the individual teacher or the institution as a whole. The common good depends on the free search for truth and its free exposition. Under the Statement of Principles, AAUP identifies three tenets of academic freedom. First, faculty should have the ability to freely research and publish. There is a recognition that there may be limitations on research if that faculty member could financially benefit or that which could impact the higher education entity if it is not in line with the institutional authority. Second, faculty should have the freedom to discuss matters within their classroom. However, the statement does encourage discretion when discussing controversial topics, as well as topics which are not related to the topic of the course, as well as the rights of institutions to limit academic freedom on the basis of religious or other institutional mission and cultural norms, as long as the faculty is notified of the limits as a part of the appointment process. Thirdly, faculty are both private citizens as well as employees of higher education institutions, and as a result, institutions and faculty should recognize and honor the difference between speaking as a citizen and speaking on behalf of the institution. In contrast, the courts view academic freedom broadly as the professional rights and responsibilities of faculty members, which can be based on constitutional law or contract law, in conjunction with recognizing the role faculty play with regard to the intellectual dissemination of information through teaching and research. Just as with private citizens, faculty are protected by the rights extended through the First Amendment regarding freedom of speech and expression at both public and private institutions, regardless of tenure status. The First Amendment rights of public employees have been upheld in a multitude of cases, with the landmark case being Pickering versus the Board of Education in 1968. You'll read about several First Amendment and academic freedom cases in your readings this week. Additionally, you will be exploring academic freedom within the classroom, in research, and in publications. It is important to note that the rights of public faculty with regard to matters of academic freedom may differ from their private counterparts. The bounds of academic freedom are also greatly impacted by institutional type. For faculty at public institutions, thus serving as public employees, academic freedom protections and limitations can be found in constitutional law, as well as contract law, state statutes, and administrative policies. Whereas at private schools, the faculty contract may be the primary source of information regarding a faculty's rights and responsibilities regarding academic freedom. Additionally, religiously affiliated institutions provide another level of complexity for academic freedom due to the mission and purpose of the institution. The Garcetti v. Ceballos case from 2006 has had a great impact on the court's interpretation of freedom of speech from an academic freedom perspective. Interestingly, this case is not a higher education law case, but as you will see, the opinions of the court can have a great impact on the legal interpretation for future cases. Ceballos was a deputy district attorney in California. As a part of Ceballos' duties, Ceballos reviewed an affidavit for a search warrant for a pending case and determined after review that the search warrant affidavit had gross misrepresentation of facts within the document. As a result, Ceballos wrote a memo to his supervisors to alert them to the concerns about the affidavit and recommended that the district attorney should not move forward with the case. The DA did continue forward with the case. Ceballos then claimed that he was subject to retaliation after the case, violating his First Amendment and 14th Amendment rights. The First Amendment claim did bring up the landmark cases regarding the First Amendment law for public employees, Pickering versus the Board of Education, and Connick versus Myers, as a basis for the claim. At the district court level, the summary judgment determined that the speech contained in the memo submitted by Ceballos was not protected by the First Amendment, as it was submitted as a part of his job duties. The Ninth Circuit Court of Appeals reversed the decision of the lower court, stating that because the conduct of the memo was about the alleged misconduct, it was a matter of public concern. The case proceeded to the Supreme Court, which reversed the decision of the appeals court, stating that, quote, when public employees make statements pursuant to their official duties, such employees are not speaking as private citizens for First Amendment purposes, and thus the First Amendment does not prohibit managerial discipline of such employees for such speech, end quote. How this case became so important for higher education law is not just the decision of the Supreme Court, but in the discussion of the academic freedom included in the opinions of the court. In the dissenting opinion, Justice Souter mentions the concern that the ruling in this case could be used in academic freedom cases against freedom of speech rights of faculty, as their speech and writing are a part of their official duties. To respond to the dissenting opinion, in the majority opinion, Justice Kennedy states that, quote, we need not, and for that reason do not, decide whether the analysis we conduct today would apply in the same manner to a case involving speech related to scholarship or teaching, as the case was not related to academic freedom. While it may not have been decided the day Garcetti v. Ceballos was decided, the basis of the speech is related to the scholarship and teaching, has created a litmus being utilized in cases since 2006 regarding academic freedom and freedom of speech. Another consideration with regard to the academic setting is that of intellectual property and copyright law. When a professor or faculty member creates a work, patent, publication, or discovery while in the employ of an institution, who owns the rights to that object? Both the individual and the institution have a vested interest in determining the ownership of the intellectual property. Faculty have an interest in the academic works they create. Higher education institutions have an interest in the items, ideas, or works created with the use of university resources. Each institution of higher education should have their own policy outlining the guidelines for intellectual property created at their institution. For example, here at National Louis University, quote, the National Louis University policy on intellectual property is intended to meet both the shared and the separate, but complementary interests of creators and the university, namely, provide an incentive for creative intellectual effort, advance knowledge for the public benefit, enhance the reputation of the university and its faculty, improve the standing of the university in the higher education community, promote academic freedom, ensure clarity in the matters of ownership of intellectual property, allow creators to exercise reasonable use of and control over the intellectual property they create, protect the university against unwarranted competition from colleges, universities, publishers, licensing agents, and other like entities, assist the creators and the university to realize tangible benefits from intellectual property, and encourage further research and creation within the university with a share of revenues accrued to the university through this policy. At NLU, our definition of intellectual property is, quote, any trademarks, copyrightable works, patentable inventions, or other similar property rights." End quote. Within the policy, the ownership and rights of use are clearly defined for faculty and the university, determining who maintains the ownership of works created while in the employ of the institution using institutional resources. From a federal regulatory perspective, 3 concepts are involved in the intellectual property: copyright law, trademark law, and patent law. For the purposes of our conversation today, we will be focusing on copyright law. Faculty legal issues apply to copyright use for education, both in looking at the use of their works as well as how copyright-protected works are utilized on campus. Congress created the Copyright Act to promote and protect the rights of authors and inventors' creations in order to support the creation of knowledge, a purpose very near and dear to higher education institutions. Copyright law has adjusted to incorporate modern works and creations to include the technological advances of recent. In order to establish a copyright, there is an application process individuals may go through to submit their works for protection for a period of time. This includes written works, such as dissertations, so you too may be a copyright holder one day. Copyright owners may reproduce their works, prepare derivative works based on their original work, distribute copies for sale or grant other ownership means, record, perform, or display the works if they are artistic in nature, or authorize another to do any of the listed above. One of the major challenges of higher education is that as a part of our purpose, we must share knowledge. How do we share others' knowledge in a way which honors their rights to their works? As a part of the Copyright Act, an exemption referred to as the fair use was created. Section 107 provides the framework for the ability for copyright-protected works to be used in certain settings, including as a part of educational teaching, scholarship, or research, without infringing on the rights of the copyright owner. In order to do this, 4 factors must be considered when determining if a use is eligible under the fair use framework: the purpose of the work's usage, the nature of the work itself, the amount of work being used, and the effect or impact of the work's use. In your readings this week, you will read more about copyright within the higher education institution setting, and it is an important area to be aware of as future leaders in higher education, as well as currently as higher education scholars.